language of this amendment because we couldn't amend an amendment in the process of voting upon it.
That is, once it had been, we'd unlocked the machine, we couldn't amend the amendment. We were past that day.
And is it not further true that when we put this bill and all amendments on the table, they were put on the table in exactly the condition they were in when we voted to table it?
That's correct.
And so, is it not true that I'm a little concerned about how now we can fix the amendment when we couldn't have fixed it before?
Because it's on the table. For it to come back off the table, there has to be a motion or unanimous consent. At that point, I call the bill again just exactly as if it had never been called. I'll call the bill and we'll go through this whole debate again just as we've done.
Thank you, Mr. Speaker.
And it's eligible for debate. Clerk, let me, while y'all are, surely y'all can, the hourly rate calculations for this right now is getting pretty high. Let's call this other bill and see what we can do with it. Was it 200? Clerk, read the caption, House Bill 200.
House Bill 200 by Representative Geisinger, the 48th. The bill being entitled Act Amendment Title 4 relating to horns, exhaust system, mirrors, windshield tires, safety belts, and energy absorption systems, so provide the failure to use safety belts may be evidence of causation, negligence, and contributory negligence, provide for related matters. Bill having been for the House Committee on the Judiciary. Committee recommends the bill pass by substitute and be read for the third time.
Chair recognizes Representative Geisinger for purposes of explaining the bill. Let me have your attention. Representative Geisinger.
Thank you, Mr. Speaker. Most of us in this body are not attorneys. So when we do something that attorneys usually do, we sometimes find ourselves maybe getting into trouble. But as you know, this bill does nothing more than initially I struck out where it said shall not be considered evidence of neglect or negligence in an accident. This is in regards to seatbelts. If you don't wear your seatbelt. We struck it out and said shall. Now, what's interesting about that is it's very simple. You know, I thought this was going to be simple. You just remove one word, not, and leave shall in there, and the next thing you know, you've got negligence can be considered. It took the Judiciary Committee, and for this reason I'm going to ask the Chairman of the Judiciary Committee to explain to you what it was they did. It took them several hours to extend what we tried to do. So we have a substitute, and Mr. Chairman, in lieu of answering any of the questions, I will ask that the Chairman of the Judiciary Committee come and explain what it was the Judiciary Committee did to the bill.
Representative Hatfield,
I yield the well.
Do you wish to yield for questions? Gentleman has yielded the well. Chair recognizes Representative Willard for the purpose of speaking on the bill.
I'm not sure what he meant by that. Let me tell you what we've done is recognized, it has been in Georgia for many, many years, the obligation to wear seat belts in passenger cars. We know there's an exclusion dealing with pickup trucks. That is a battle that we're not going into with regards to this bill. We recognize that the law on pickup trucks is pretty much sacred with some people, and so as it came through the judiciary, we looked at recognizing there's a public purpose, we believe, in having people acknowledge the fact that we passing laws do things that encourage certain type of conduct. When we passed the original bill about requiring in passenger cars the wearing of a seatbelt, this body was speaking to say that we believe is important conduct that the people of this state should comply with when you're in an automobile, not only as an adult but as to children. And we were doing what we did as far as the language in the bill to maintain the same requirements we have as to the wearing of a seatbelt. So you look on line 12, it talks about the failure of an occupant of the front seat of a passenger vehicle. That is what the current seatbelt law requires, is only passengers who are in the front seat of a passenger vehicle, believe it or not, to be the ones obligated to wear a seatbelt. So we were not going to expand the current legal obligations under the law who has to wear a seatbelt. And the passenger vehicle is defined in the law as being one that carries 10 or less people, and you have a specific exclusion as to the pickup truck. So we use the term passenger vehicle for that reason. Now, as you come down further, I want to talk about why and how we worded the issue on line 16. We said the person who wears that seatbelt shall not be in any basis for cancellation of coverage or increase in insurance rates, but shall be considered evidence. If you don't wear the seatbelt, in other words, if you're in an accident, you're hurt, your insurance company cannot use that as a basis to increase the cost of your insurance. But it can be considered as evidence in mitigation of a party's damage only if the court finds, A, the party introducing such evidence has pleaded such failure as defense. That's what the lawyer who is defending against a claim for damages has say, well, you didn't wear your seatbelt, so part of your injuries may be resulting from that failure. And part B is the person whose injuries are subject to a claim was at least 14 years of age. So we recognize that there's an obligation of parents to require them to put seatbelts on their children, but if they didn't do so and that child was injured, we don't want to say the child is, because of that, a negligent party. That's not the case. Third thing is C, the party offering such evidence proves by expert testimony that the injured party's failure to use a seatbelt contributed to the injuries claimed by the plaintiff. The purpose of that is to say that you just can't come and say, well, you didn't wear your seatbelt, therefore you're not entitled to damage. You have to show that because of that failure, if you are the passenger seat, for instance, you don't have your seatbelt on, you're in an accident caused by the negligence of somebody else, but you then go through part of the window in your head's banged up bad, you got bad cuts, you got brain injury, whatever it may be, a doctor is going to be able to come in and say the failure of having that seatbelt on did in fact give injury or cause injury to you that would not have happened if you'd had your seatbelt on. The mitigation part that we speak of says that it cannot be a loss of all rights of any damages. Now, you remember a few years back we passed a law where as part of tort reform, where we did the contributory negligence law, where people are now able to, in a trial, recognize if I and Mr. Neal were involved in an accident or whatever it may be, and I am found to be 50% liable, and he's found 50% liable, I would have no recovery because we had equal amounts of negligence. That's the contributory negligence part of it. Mitigation is different. I could have been equally liable. The jury can mitigate, means they lower my damages by a 50% amount based upon what may be the determination of those injuries I received that resulted from my failure to wear the seatbelt. So we did not remove the right of full recovery. We recognize there can be the reduction of recovery by mitigating those damages according to how much loss I had and what the testimony, the evidence is in the court. The part 2. This is where we're talking about the mitigation of damage. If the court finds that the evidence supports the findings set forth in paragraph 1 of this subsection, the trier of fact may find that the plaintiff's failure to wear a safety seatbelt in violation of the subsection contributed to the plaintiff's claimed injuries. That would be the jury making the finding, and may reduce the amount of plaintiff's recovery, provided, however, that notwithstanding subsection G of Code Section 5112